I want to welcome everybody. This is the first week of It's Your Estate. We go for 6 weeks now, not 8 weeks. So we are delighted to have you join us, and I will share a screen.
Welcome, Mark. Can you go ahead and put your outline and ask first on the screen? Or do you want Don to do that?
Well, I don't have the ask first. So
okay.
If Mark's got it, that'd be better.
I've got it. Let me just get it up here.
All righty.
And I'm going away. And if you ask questions on Q&A, I will respond during the sessions or ask Mark or Pete questions as we go along. So feel free at any time you'd like to ask questions, we can do those. And I'm going to disappear. Bye.
Bye.
All right, let's see. For a minute, it's going to be like watching.
There you go.
There you go.
We ask all of our presenters to complete an ask first form because it just gives a brief introduction into their education. What's your master's and other advanced degree, Mark?
So it's a law degree.
A law degree.
Mm-hmm.
And how many years have you been in an attorney?
So I got admitted in '96. It makes me 25 years almost.
And out of those 25 years, how many of those have been in the estate planning area?
24.
Okay. Why do you think that's important? I mean, you mean a regular attorney can't do an estate plan?
Yeah, so estate planning is a bit of a niche. It's to get good at it, like everything else, right? You got to put your 10,000 hours in, right, to develop a mastery. And so I think if you're not doing it full time, if you're not really focused on it, then you pick up things and you may know the basics, but when difficult issues come up and you haven't spent many number of years at, working with the same kind of issues where you can draw analogies and make good decisions and help clients figure out what kind of complexity do they need. That's the most important thing about my experience, I think, is I can help clients figure out what level of complexity they should really have in their plan.
Yeah, I would discourage individuals of doing their own estate plan. Probably the self-done estate plans are the ones that usually end up in court. Mm-hmm. And I would not use just any old attorney in an estate plan. I would use someone who had at least 5 to 10 years experience in the estate planning area. What does it mean to be a certified specialist? Something you buy, or you just put it on a sheet of paper? What does that mean?
You print up your own diploma. And, No, so to get to be a certified specialist, you have to take a second bar exam. So you have to be 10 years of practice, and then you submit and you take another whole day bar exam just on estate planning. And then the state bar checks references, the peer references. So other attorneys who are also specialists in estate planning have to tell the state bar that they think you are qualified to be considered a specialist. That's my first check on people that when I help people find attorneys.
Yeah. So one of the first things a person can do if they're looking for an estate planning attorney is go to the California Bar Association and put in certified specialist in estate planning. And I think there's about 200 to 300 in the entire state of California that are specialists. And as you say, it's like taking a second bar exam. It has some meaning. It's not just something you put on a piece of paper. What does it mean to be a fellow?
So after about 10 years, there's another organization, a national group of estate planning attorneys called the American College of Trust and Estates Council. And they're all the people, the goal of that college is to help teach other attorneys about estate planning techniques, help guide legislation, whether it's state legislation, federal legislation, IRS proposed regulations. You That's what the college is. So you have to get voted in by other members of the college. They look at how much have you done writing for other attorneys, how much presenting have you done for other attorneys, and
Oh, it's fairly prestigious.
It's hard in the whole country. I think there are about 1,900.
Right, and you are one of them.
And I am one of them. In Orange County, I think we have 7 others. So
Okay.
It's a small group.
Yeah. The other thing I want to mention is when you're looking for an attorney, there's also an association called the Academy of Elder Law Attorneys. Academy of Elder Law Attorneys. And those attorneys focus in on individuals who are on government benefit type programs. So that's another whole group within the estate planning area that you may want to consider depending on what type of need that you have. All of your license to practice in California, there's your license number. I always encourage people to look everybody up, whoever they run into. What is so unique about the estate planning area is every state different comparatively to their laws in the estate planning area compared to, let's say, if you're licensed in California, can you practice in Nevada estate planning?
Only if you also practice, take the Nevada bar.
Okay.
Because every state's got different rules, and California doesn't want people who aren't familiar with our particular probate code advising people on what's going to happen in California.
Okay. So 2 things there. If you move from one state to another, or you have property located in another state, you need an attorney in that particular state. Is that correct, Mark?
Yeah, like we don't even transfer deeds, or when I was in law firms, we never would even transfer properties that were in another state. We would go and find a lawyer in those states to help with that, because California's deeds and recording system is not like other states. So it's always important. It may seem like an overkill, it may seem too expensive, but if you really want it to be done right, you've got to get somebody in that state making sure your documents are right, they're executed properly inside that state, so that when it's time for them to be of use, you're not going to run into problems.
Yeah. So let's talk a little bit about expenses. I want to first of all speak generically, because you have been with many different firms and have some experience with the legal industry here in Orange County. What is the average or range of fees that someone would pay for an estate plan here in Orange County?
So I have to give you a lawyer answer, which is it
depends.
It depends. But I'll give you some distinctions. I think there's a core set of documents, and we're going to sort of overview what that core set of documents should be that pretty much everybody who's doing estate plan should think about. And unless you're going to one of the really big firms, in Orange County, I would think for that core set of documents, you're probably going to spend $3,500 to $4,500. You will find people who will do it for $25, and then you'll find big firms who will tell you it's $10.
Yeah. So the range here in Orange County, I would say, is it's about $1,000 to up to $10,000. The range average being around between $2,000 and $3,500. That's kind of where I'm finding it. What do you charge? You're highly experienced, so I don't want you to think you're not the norm. So how much do you charge?
So my last hourly rate was $1,100 an hour, and it would cost about 10 grand for me to do a core set of documents. Now, not everybody needs that. Most of my clients had advanced plans, and we needed to do really specific estate tax and other tax planning. So I wouldn't expect you to spend that kind of money unless you've got those really sophisticated needs. I would, if you came to me and you didn't need those, I would strongly encourage you to go somewhere else, because you just wouldn't be getting the value that, for the money based on what you need.
Now,
So
Pete, I'm going to ask the question, which might link into this. I noticed under legal services, you don't practice law anymore.
Oh, somebody's reading ahead. Yes.
Well, no, he jumped to fees, which is below this.
Oh, did he? Oh, okay. Yeah. So I'm a bit of a unique person to be presenting, I think, because I did estate planning as a lawyer for almost 25 years. Last fall, I decided it was time to do something a little different. So now I work in a family office setting where we take, I've got about 25 or 30 clients who are very complicated estate plans, and just day to day, I help them administer their estate plans. So I'm not really practicing law in the general sense, although for those clients, I'm doing a lot of things, but yeah, so I'm not, if you call me up later and say, Mark, I've got to get you to do your estate plan, I don't care if it's 10 grand, I'm still going to say I can't do it, because my situation is just different right now.
Okay, let's go your contact information. If you scroll down a little bit, Mark's contact information is there. And one of the nice things you've done is you put in the purpose of the Ask First form, which is really nice. So people can take a read through that. And there's a blank one on our website that people can use for anyone who wants to. By the way, how long did it take you to complete the Ask First form?
5 minutes.
Yeah.
And mostly that was fighting.
Was there anything offensive about it, or?
No, mostly it was fighting with Adobe.
Yeah.
But yeah, no, I think it's a great form, and
it's a quick way to learn about compensation, financial products, credentials, their education, etc. And so we recommend highly people use it. Let's go to your.
Can I throw one more thing on this? So if you are out and you're using this form, or you're just interviewing attorneys, there's one other thing I think that you could look at. You can go to the state bar's website and search for legal specialist, and you can do it county by county or a certain number of miles from your zip code. It's really pretty helpful. You can go to the American College of Trust and Estates Council to find a fellow in your area. Another one that people look at is Martindale-Hubbell, and that's completely free. You go to Martindale's website and you can search by attorney, and they get ratings. And again, it's by peers. So AV is the highest rating, which means you're A on ethics issues, and which is the best grade, and V, which is the highest, it's number 5. It's the top category on experience and knowledge in the area. So that's another thing that you could look at, is people who have look for AV ratings in Martindale-Hubbell.
Okay. All right.
Before we go forward, somewhat on that, Mark, somewhat on that same point, someone had asked the question, if the lead attorney in the firm is certified estate specialist, but I'm working with an associate, is that a concern?
No, I think if the lead is certified and the associate's going to be working, through the partner, like they usually do, then you're going to get the benefit of that certified specialist experience, because the senior partner should be teaching the associate. It takes a while to be able to even apply for legal specialization. So as long as you're in a firm where you can see that that's the kind of expectation the firm has for its practitioners, I think you're fine.
Let's get to the outline.
All right. Let me fight with Adobe for another minute.
Okay.
Okay. Can you see that?
Yep. Perfect.
All right. Here we go. I'll just go.
Yes.
All right. So nobody cares about this slide. This is just telling you where I am at advice period. All right. And nobody cares about this slide because you're all here. This is the introductory session. So here we go. The material of this. And I really do appreciate questions as we go along, because I want you to get out of this a good overview so that you're ready for the next few weeks of this. So anytime there's a question, let me know. If you see something in the slide that doesn't make sense, let me know. But we're just going to go with this. When I'm doing estate planning for somebody, the very first partner I ever worked for told me, we only do estate plans that work. And you say, well, what the heck does that mean? What works? And he says, it means if 9 months after somebody dies, they're looking up or down or back or whatever it is, and their plan and their family is really being protected and really being cared for in the right way, the plan worked. So that means, excuse me, we have to take into account things other than the technicalities of what's a good document, what's a good tax plan. And we have to start with you. So this is on the left, that's you. And then what are we trying to protect? Well, first we want to make sure we know your desires and your wishes. And that worksheet that we were looking at the beginning, or the workbook, as you go through these different sessions, there will be topics that will come up. And if your estate planning attorney doesn't know your desires, either because they don't ask enough probing questions, or because you haven't thought it through in a way that you can express it to them, you're off to a bad start. So going through these workshops, thinking these things through so you can actually put your desires and your wishes into words is really, really important. The other two things that we want to protect are your autonomy and your assets. So as we go through this, we're going to talk about the default instructions that exist for your estate plan. You have one, whether you know it or not. And we're going to talk a little bit about what that plan is and why it might work and why it might not work. But one of the things in that plan is autonomy. There are ways for our default system to start to rob you of the ability to make decisions and give instructions, and we don't want that. So one of the things we do in the core planning part is make sure we cut off every avenue to those court proceedings unless they're really needed. And finally, your assets. We want to make sure your assets go to the people you want them to go to, and they're used the way you want them to be used. And in no other way, which means as you're talking to attorneys and you're interviewing them, or you've picked one and you're working with one, you've really got to be able to tell them, look, this is why I want to do this for this particular beneficiary, and maybe that for that particular beneficiary. Because in estate planning, fair is not always what we're after. Equal is not always what we're after. We're after fair. We're after treating your beneficiaries with your assets the way you want to, based on your desires and what you want for them. So here are the people that we're trying to protect from. Right, so the first one, I'm just going to talk about these, but I bet everybody's got experiences, everybody's seen these situations. My parents are now in their 80s, and I'm watching this overreaching family member thing start to develop because, they're still sharp. Nobody understands why they still live in Georgia, but other than that, they should be able to make their decisions and decide what they want to do, and it's their money, it's their estate, and these overreaching family members, you really just need, to put up and just talk to the hand, because nobody cares what these overreaching family members are saying. And yet you'll have children, grandchildren, siblings, nieces, nephews, all sorts of people start to come up with, well, this is what I think you should be doing. And if you're not doing it, something must be wrong with you.
Yeah. By the way, I would say a professional fiduciary, number one reason why we're involved is because of overreaching family members.
Yeah. It's just getting worse and worse. And
yeah.
So
and the more money or assets in an estate, the more overreaching begins. It's almost like a curse. Right.
And family members don't realize, during life, I can do whatever I want to. I've got 2 kids and no grandkids yet. Whew. But, it's my choice. If one of them is going to go to Harvard and needs that money, that's fine. If one of them is going to community college and that's all the money they need, that's fine. And if I want to buy a Ferrari, that's my choice. There's nothing about getting old that means you can't make those decisions. Now, incapacity is another thing, and we might as well jump right. Well, no, let's keep going in order. So we'll get to incapacity. So unwelcome court involvement. You would be surprised, and Pete, I hope will back me up on this, that it is very easy for some family members, somebody who, it could even be a neighbor of yours, a friend of yours, you can trot right into court and start a court proceeding because they think something is wrong with your life. And it's shocking to me how fast that can happen. And it's discouraging and really just disappointing how easily it happens, and the courts don't stop it. The judges don't look at it and say, this is not what we're going to do.
Well, I hate to bring this up, Mark, but I know you were kind of peripherally involved with the Britney Spears situation, and that's a perfect example of the courts overreaching.
Right, 13 years of total control that got started, and she had nothing to do with it. It was completely involuntary, and so that's another thing, is we want to make sure we cut off any avenue to court involvement if we can. We also don't want, on Britney Spears, we don't want any of these unwelcome protective systems like custodianship or guardianship or conservatorship. It's called different things in different states. California's got two of them. They think of guardianship as being the protective proceeding, and that means a judge has decided that the person's ability to deal with their life is compromised in some way. So they're going to put another person in charge. It can be because their parent, they're under 18 and somehow they inherit a lot of money and they're not old enough to do it legally. Addiction problems, physical incapacities, mental incapacities. It can be all sorts of things, but a court can basically strip away all your rights and put them into somebody called either a guardian, if you're not an adult yet, or a conservator if you are an adult. So we want to make sure we stop that as much as we can. We get many things in the way of a proceeding like that so that we discourage courts from ever letting it happen. And that really does go into our fights about capacity. We don't want anybody, to go to a court and say, well, I think Mark's incapacitated because, he just bought a Ferrari. People will make up crazy arguments about capacity. And it's actually pretty hard from a lawyer's point of view to prove somebody is incapacitated, but it's really easy to get the court to question whether somebody's incapacitated, and you end up in a big fight.
Yeah, and the problem today is that financial illiteracy is rampant, and financial abuse is rampant, and so you have a push-pull with capacity issues. Mom has son living with her, and son is using her credit card. It's people believe that naming a family member, no matter if the family member doesn't show any competence whatsoever, is better than naming a person from the outside.
Yeah, there is a very strong preference in the courts for family members.
Well, even within the family.
Yeah, even within the family. So, when you're thinking through who are the people you would give the jobs to, that we'll discuss in a little more detail, but they were outlined in that workbook, who you would give those jobs to. I strongly encourage people not to default to family members. Now Pete can answer this question. I mean, if somebody's got to make healthcare decisions for you, maybe that's a better.
Even there, it's very, very difficult for a family member because of the emotions.
Right. My mom made us put into her healthcare directive that if she went into the hospital and she couldn't, we didn't know what was going on, we had to give her 9 months, for the doctors to figure out what was going on. She was afraid we'd all rush and pull the plug. Yeah. So, she was a little bit strange, but very thoughtful of her to say, all right, this is what I want to have happen.
Yeah.
She told us it took 9 months to come into the world. It should take 9 months to go out of the world.
I like that. But again, this is where you got to give some really careful thought as to who in your family are you going to name. And we're going to be talking more about this, but in my own family, naming my mother as the healthcare agent was the worst decision that my dad made, because she just wasn't competent and couldn't handle it emotionally. She didn't even like hospitals. So it was very, very, very difficult. So, I mean, you got to give all of this stuff a lot of thought. There's no easy answers.
No.
And every family is different.
Yep. And yet, I guess on the other side of that is, don't get paralyzed by indecision about this. It's better to get something in place, even if you need to change it, than, to just constantly put it, well, it was on this year's New Year's resolution list. Now it's going to be on next year's New Year's resolution. Because I can't figure out.
The most often heard line that I hear is, I'm going to do the estate plan as soon as I figure out who's going to get my sofa.
Right.
And
you really do want to say, nobody wants that sofa.
Yeah. Well, that's a whole nother story.
Yeah. Let's get on.
What do you mean by tax agencies?
So as we do now in core planning, we're really worried about your desires, protecting you from unnecessary complications. And when we get into advanced planning, we're doing a lot of tax planning, right? Because there's the estate tax, there's income tax issues. If somebody inherits, what does that mean from an income tax basis for them? What about capital gains? So there's a lot of tax rules that eventually become really important in this. We're going to hit on them on the highlight of the federal estate tax and state estate taxes. But that's another one. We want to do some planning. If you are lucky enough to have a taxable estate, which these days means you've got more than $12 million. And if you're married, you've got more than $24 million, then you need to do some tax planning. But that's what I mean. We don't want 40% of your assets disappearing unnecessarily.
Yeah. And the good news about California is there's no inheritance tax in California by the Constitution.
All right. Now, Pete just ruined my last slide. So when we get to my last slide, act surprised. All right. So here we go. Core planning.
Mark, you had made a comment in terms of asking questions as we go along. Yeah. And it's actually already been answered for you. Several people had asked the question of what was the name of Martindale, or it was a website or something else. And one of our participants found the website. I just put it on the chat. So if any of you are sitting there, you move your mouse around and you can see the little chat thing says 1 on it. If you click on that, you will get the website for it. So that answers the question that a lot of people had. So just wanted to let you know we're taking part in it.
Perfect. Thanks. And that really is a good one because it's all peers, other lawyers saying what they think about the lawyer in question. So So I'm glad that's there. Core planning. All right. So here we're going to talk. The first one. Overreaching family members, unwelcome court involvement, unwelcome protective proceedings, protecting yourself during incapacity. Incapacity has such a bad name, right? I mean, it just sounds really like a bad situation to be in, but it does happen. It can be, I've had clients who were old enough that a fall, broken hip, and suddenly they're in the hospital and in recovery and recuperation for 6 or 7 months. Well, that's kind of a period of incapacity because they can't get up and go to the bank and deal with their finances. They can't go to see an attorney to take care of planning that they may need because they're physically incapacitated. So what we want to do during periods of this is preserve your autonomy. Make sure that there are still ways that you can get things done that need to be done based on your desires. So let's talk about a few of those, but this is really important to me. I watch, you have your life experience, right? So I watch my parents. They just finally moved into a retirement community at age 83 and 85. And there's not a doubt in my mind that they have been abused by the builder and abused by the system, taken advantage of. They've been overcharged, and the people are treating them like, well, you're 85. We're just gonna have to baby you through this, and maybe you really don't understand what's going on. It drives me crazy, and yet it's the hardest thing to protect against unless we do some really good core planning. So let's talk about ways to do that. The first thing is you got to have a healthcare directive. And there's a whole session that's going to come up on powers of attorney. So I'm just going to tell you the basics of what this is, so you can start to think about issues for yourself. Right? So your healthcare directive in California is called an advanced healthcare directive. In other states, it's called just a healthcare directive. It's called a living will. It's all sorts of different things. But the idea is you create a document that, one, appoints an agent, someone you trust to make healthcare decisions for you. And it's not just trust. When you appoint these people, you've got to find somebody who has some competence in the area, who has the time to put into what they're gonna need to do, because it can be very overwhelming. And then I think for the most part, you need to find somebody geographically close, so that if something comes up and you need to go to the hospital, they can meet you there. And it's not a 6-hour plane ride, and maybe I can be there in 2 days. But Pete's got something to say.
Yeah, no, I just see people naming individuals from out of state and out of the county, and they think they can do it by phone and fax and iPads, and you got to be there.
Yeah.
There's just no way around it.
Yeah, I think it's absolutely true.
It's a medical industry.
Yeah. And doctors are going to be more comfortable, no matter what your document says. Once they accept your document, they know who they're supposed to be dealing with. If all they get are, cracked up conference calls over cell signals and, Zoom calls where they can't even show you, the x-rays or things, it just doesn't make them as comfortable. And I think doctors become more resistant when there's not somebody standing in front of them.
And somebody has to know, and we're going to get into this, but they need to know what medications you're on. Have that list as part of your healthcare directive. I just got this the other day for the emergency room. We didn't have it. It took us another 5 hours to find it. Not good.
Yeah. So in your healthcare directive, California's version, you're going to do two things. You're going to name an agent, and you can name successor agents. So you can say, this is my first choice, this is my second choice, this is my third choice. So, that's nice, because if somebody's out of town, even if you named them and they're geographically present, but they're on a cruise for 2 weeks, well, we just go to number 2, so that you're not sitting in a hospital not getting the care that you need because the doctors can't get to your agents. The other thing that you do in a healthcare directive, if you want, is give instructions about end-of-life decisions and what types of life-sustaining treatment that you want. In a lot of other states, those two things, the agent for making healthcare decisions and the instructions about life-sustaining and end-of-life issues, are in 2 different documents. But in California, they're all in one that's called an advanced healthcare directive. And if you go to the California Attorney General's website, there is a statutory form that you can pull right off there. The California Medical Association has one. California Hospital Association has one. And these are the things that doctors are used to seeing. So you can start looking at them and start thinking through, what you're going to be asked when it's time to do one of these.
Mark, thank you for making this the number 1 document, but we're going to go through essential documents that every person should have. Healthcare directive is number 1. What's the number 2?
Number 2 is you need a durable power of attorney for your assets. Here's the weird thing about the way a court will look at you, if a court ever does look at you. They will not see one of you. They'll see 2. they'll see your person, your physical person, and where it needs to be, and what kind of healthcare it needs, and what kind of treatment it needs. And that, if you go to court and a court gets involved and they decide to appoint a conservator, someone that they're going to take away all your power, give it to somebody else, they're going to appoint a conservator of the person and potentially a conservator of your assets, your estate, right? So your healthcare directive is the thing that cuts off the race to get a conservator of the person established. Because I said we want to cut off all the avenues that we can. So by getting a healthcare directive, keeping it current, I would do, even if you don't change any of the people, I would do one every 2 or 3 years, just so it's a current document and you don't have somebody looking at a 10-year-old document wondering if it's still what you meant.
I always remind people it's like bread. You know, you want the bread to be fresh.
Right. And again, once you have one of these, it's not that hard. You just sign it again if you don't need to make any changes, but that's important. That cuts off the path to a conservator of the person. Your durable power of attorney is going to cut off the path to a court appointing a conservator of your estate, because your durable power of attorney for assets, I guess I really should have put that durable power of attorney for assets, is who's going to pay your bills, who's going to deal with your investments, who's going to take care of, if you've got rental units, who's going to collect the rent? If you owe rent, who's going to pay the rent? If you've got a mortgage, who's going to deal with the mortgage company? All those things that may take a different set of skills than participating in healthcare decisions, which is why I think, you end up with 2 of them, as courts do recognize that it can take a different set of skills. But we don't want a conservator of the person. So we're going to do a durable power of attorney for assets. And in that document, you're going to do a few things. You're going to first appoint a person or a string of people that you would want to do this for you and that you would trust and that you feel comfortable telling your desires and wishes to. So when they have to act, they're not guessing. You've had a conversation with them, you've told them what's going on, and they now have something in their head about why they should do it this way instead of that way. Because just putting it in a document and surprising somebody on a day down the road isn't helpful. So you want to be able to talk to them. And then in your power of attorney, you figure out what powers do you want to give them. Some lawyers would draft a 30-page power of attorney for assets, and some lawyers will draft a 3-page power of attorney for assets. And it's completely different mindsets. The state, if you were to go to the Attorney General's website and pick out the one that the state legislature has sort of put together, it's like 3 pages. And it has a whole list of powers, A through N: real estate transactions, banking and financial institution transactions, retirement benefit transactions. And you go down the list, or you go to the very end and say, I want my agent to have all these powers. And so that makes this power a general power of attorney, because you're giving them lots of general powers. You can give somebody limited power of attorney, just somebody deal with your rental apartments, or whatever it is. But even if you have one of those, you need one of the general ones, because the limited's going to run out really fast.
So, and by the way, do the married couples or each have to have one? In other words, can a spouse handle their husbands without a durable power of attorney?
A lot of people will tell you yes, that just because you're married, the banks are going to listen to you. I will tell you, don't count on it. Do your own. Each of you should have one, even if you're appointing each other. Because when the time comes, you want a document that you can shake in somebody's face and say, you got to listen to me, because here's the instructions.
Yeah. We're going to go through, we're going to go through lots more details on this, but this is an essential document that you need to have. What's the third document that we're going to talk about?
Third document is nomination of conservator. Even though we are doing everything we can in the core planning here to make sure we're cutting off avenues to court, we want to have that backstop that says, well, if a court ever decides I need a conservator, here's who I want to serve in that role. for healthcare, for assets, maybe it's 1 or 2 or 3 people, but you want to say in a document that's legal, that's executed properly, prepared hopefully by an attorney, so the attorney can come in if they have to and say, this is why Pete wanted Mark as his, healthcare agent, whatever it is. So you want that document, and it's another way to control the process. So even if you get into a court situation like that, at least you put your wishes down on who should have those jobs. And I think that's really important. You can do these in a standalone document, or you can do them if you do it for the healthcare part. You can put in your healthcare directive a nomination if a conservator of the person is ever needed. Here's who I want it to be. And you can put into your durable power of attorney for assets if a conservator of the estate is ever needed. Here's who I want it to be. So it can be done a few ways. I've even seen people put it in their wills, but I think you want to have it there. You want your wishes known about this. And the same thing, it's a simple document. I'd sign a new one every few years so that it's not stale. And then the other great thing about having a few of them that you can go back in history is that you can see you've been really proactive. You've been really thoughtful about this
and you've been consistent.
Years, and you've been consistent.
Yes.
Right. Because that's the thing where family members will overreach is they'll say, what, all of a sudden, some neighbor's going to be the healthcare. Yeah. I'm the kid, I should be. But if you've got 3 or 4 sets of documents that have consistently said, I don't want my kids.
Yeah. What happens today a lot is the family members will go attorney shopping, and they'll take mom or dad out to a different attorney and develop a whole new estate plan. And mom or dad doesn't understand really what's happening. We're living longer. So you've got these documents protect you, I would say, from the age period of 90 to 100, where you may not be as sharp as you were at 70. So you got to think about these things. And that's why that workbook is so nice and handy, is to think through who these people are. The document itself is not the answer. It's the people that you pick to carry out your wishes. Really important. Let's go to the next slide.
All right, so we're going to turn a little bit now. We're getting out of incapacity, and we're going to talk about what happens at death. And this is where I'm going to tell you about the estate plan. Yeah, I'm going to tell you about the estate plan that's already in place for you, and about the conservatorship plans that are already in place for you. Because the California legislature many, many years ago put together these plans. And they say if somebody dies in California without their own estate plan, our default plan applies. So here's the default plan for inheritance, right? So this is called intestate succession. Intestate, like inflammable. Testate means you put your instructions together, and so you only worry about these default plans if you haven't put anything on paper. So our first rule in intestate succession is that we're going to go down the line. So here you can see in the top left, that's you. And I put a man and a woman so that whoever you are, that's you. Then the first stop on the rule of intestate succession is we're going to look for a spouse. And if you have a spouse, everything's going to go to your spouse. Now there's a caveat to that, but let's just start with that general rule that the rules think you want to leave everything to your spouse. That same rule will go back to your nomination of conservator and say that the expectation is you're going to name your spouse. Remember we talked that there was a bias in our rules looking for family members. Well, this is how it comes out. This is where it starts. So if you want somebody other than a family member in any of these roles, you really got to put it down and make it clear. So first we're going to go with spouse. Then we're going to look for kids. And then we're going to look way down and look for grandkids or great grandkids or further descendants going right down the bloodline from you. California's rules on who counts as a child are pretty broad. So children that you are biologically the parent of, definitely yours. Children that you adopt, yours for these purposes. Children that are stepchildren, if you have had a parent-child kind of relationship with your stepchildren, they count. So it's a very broad definition of child. And so one reason to think about this is if you want something different, you've got to change it. You got to do your own planning, or else these rules are going to apply. Grandkids is pretty easy because any of those people that I just talked about who could be kids, any of their kids are going to be treated as your grandkids too. There is a distinction here between community and separate property that I want to draw up. The expectation is you will leave all of your community property to your spouse. And community property is broadly defined as any asset that you've acquired while you were married. And the thought is, well, if you acquired it while you were married and you were both living on it while you were married, it's fair for the spouse to be able to continue living on that asset and its income and what it earns after you've passed away. Separate property, though, is treated differently. Separate property is assets that you had before you got married. If you had a house before you got married and you've kept it, then that's your separate property. Separate property is really hard to keep over the years, so you have to be really careful about it. So I'll just throw that out there. But the general rule is assets that you had before you got married that were given to you while you were married or that you inherited while you were married should be separate property. And the intestate rules say that when it comes to separate property, it's going to be split between your spouse and your kids. Depends on how many kids there are. If there's a spouse and one kid, then it's 50-50. If there's a spouse and more than one kid, spouse gets a third and the rest of it gets divided up among the kids. So you may think, I'm married to this person and they're going to get everything because I'm married to them, but you need to know that this intestate rule does not say that. It could cause conflicts right away between spouses and kids.
Especially with second marriages. Mm-hmm. It's become a major item. And people think that everybody has an estate plan. The vast majority of folks who are living today do not have an estate plan. And most people who die today die intestate.
Yeah. Terrifying statistics. The last one I saw was that 83 or 84% of people had no estate plan. That's just
people
crazy.
Don't like attorneys.
I get it.
Let's go to the next slide. By the way, we put an entire article on our website under material along with the workbook on intestate succession. So if you want more information, please go there. Google intestate succession, gives you a lot of information as well. It's an important area.
It's very important. It's important for you to understand it enough to realize you don't want it.
Yeah.
So this was a down the line. This is assuming that you're married and you have kids. But what if you don't? What if you are single or at the time of your death, you're not married? Keep in mind in this, legally separated does not stop inheritance, right? Our intestate rules will say, unless you're actually divorced or do something specific, if you're separated from your spouse is still going to be considered your primary beneficiary. So that's just an aside. Back to this. So this is our other choice of intestate succession. We can't go down the line because there's no down the line to follow. So now we have to go back up. So here at the top left is you again. First stop, if we are looking in this backup version of intestate succession, is parents. So my choices in these icons were very limited, and I don't like some of them. So don't be offended by the king. But so that's stop number one. It's going to go to your parents. If your parents are both alive, it's going to go to them equally. If only one of them's alive, it's going to go to the survivor entirely. If they're not alive, the rules are going to look for your siblings. And same thing, if there are 4 of them alive, they're going to all 4 share equally.
Well, we had a situation where gentleman was 96 when he died, had no estate plan. He was the youngest of 9 children. So when he died, it went up the ladder, like you say, and then went to his brothers and sisters. Most of them had deceased. So we were looking at 245 beneficiaries of nieces and nephews down the line.
Yeah.
All over the United States.
A nightmare situation.
Yeah.
Because
So
one of the things,
Mark, I want to make one point. Just because we're scaring the crud out of people at the moment, I just want to
Sorry.
make sure that it's understood that if you have a will or a trust, intestate, and it's valid and signed and everything else, intestate does not apply.
intestate does not apply. Exactly right.
So that's how you
you're right.
overcome intestate, is do something about it.
All you got to do.
Thank you.
Yeah, it's a good point. Yeah, we are scaring you a little bit, but all you got to do is get a document in place.
Yeah.
And that's it. And I know you've got lots of really good people who are going to come and talk to you about these things, over the next 7 weeks. But California has a statutory will. You can download it right from the Attorney General's website. And it is, who do you want your house to go to? You put the name in, you sign. Who do you want your bank accounts to go to? You put the name in and you sign. So it's really easy to avoid all of this horror.
California Medical Association, you can get their form for $15 on the internet. Most hospitals will give it to you free. Council on Aging will get it to you free. Cost is not a reason not to have these documents.
Right.
And we'll help you. If cost is an issue, let us know. We'll get you through it.
Yeah.
Let's go to the next slide.
All right, we're going to stop terrifying people and start helping you. First, to do that, though, is really important for you to understand title. Because title has everything to do with how your assets are going to be distributed. So let's just go through this list and make sure everybody understands these different forms of title. So individual title. I buy a house. I put it in my name. My name is the only name on the deed, right? That's individually named. That's an asset that's just in my name. Now, we don't have to think too far to realize the problem with this. What happens when I die? Because to transfer title to a house, the current owner needs to sign a deed, right? Transferring it to the new owner. My name's the only one on there and I'm dead. I can't sign a deed. So we are headed straight to probate, which is, we'll talk about that in a minute, what that whole proceeding looks like, but we're heading straight to probate when you have a lot of your assets in your individual name, because there's no other way for anybody to take control of those assets after you die. So first choice, Pete, did you want to say something?
Well, I was going to say, what happens if you suffer some kind of incapacity and you need to sell the home to get into an assisted care facility?
Yeah, very good point. You're not going to be, unless you have designated someone as your power of attorney and you've given them the power to deal with real estate, then they could come in. They would record their power of attorney with the county so that the agent's name goes into the chain of title, and then the agent can sign a deed transferring your house, selling your house, mortgaging it, whatever needs to happen. So it's not the end of the world, but it means if you don't have some other things in place, it's likely the end of the world.
Yes.
So the other choice, and this is really easy to do in California and easy to do in most other states now, is you can add a POD, a pay on death provision. Some places call it a transfer on death provision. But I can have an asset in my individual name where I've already told the person who's got physical custody of the asset, if I die, I want you to give those assets to this person. So think of a bank account, right? I open up a checking account, I open up a savings account. It's in my name because it's my money. But to avoid having to get a court to tell the bank, who do you give the money to when I die? I go ahead and tell them. I just put it right in the contract with the bank that says, when I'm gone, here are the people who get the assets in this account. Easy thing to do, keeps you completely out of intestate succession, avoids court involvement. Not the best planning, but a good first step.
And it could be a good way to transfer some monies, small amount of monies at the time of death or incapacity. Well, not at incapacity, but at the time of death for somebody to have some cash in hand.
Yeah, absolutely true. Because whatever kind of, when you do a plan, whether it's will-based or trust-based, there's going to be a lag between the time that you die and people can access your assets. So to use something like this to provide, 25 grand, easy access. Now the person who's in charge of your stuff can go hire a lawyer because they've got some money.
Joint tenancy is the most common form of ownership that I see, and it's probably the most troublesome.
Yeah, joint tenancy. So let's just say Pete and I decide we're going to start buying some investment properties together, and we're going to take them as joint tenants, right? It's realtors love joint tenancy because it gets the question when you ask them, how should I take title? It gets it off their desk because they just say joint tenancy. That's what everybody does. Here's what joint tenancy means. It means that the second I die, by operation of law, there's no court proceeding, there's no procedure, administrative procedure that has to happen. The rules say that my joint surviving tenant owns the property. And all Pete has to do to get my name off that property is wait for a death certificate and then send it to the county, and he now owns those investment properties.
100%.
Easy, fast. One of the good things about joint tenancy is it will pass to Pete free of all of my creditors. So one of the things that California is really worried about is making sure that my creditors get paid before my beneficiaries get my assets. Joint tenancy is one of those weird rules where it passes to the joint tenant and creditors are out of luck. So that's there. But the problem with joint tenancy is, well, okay, I just solved the problem for when I die, but we don't know what's going to happen when Pete dies now, right? So if it was just the two of us, we'd go back and forth. But now Pete's going to have instructions that he wants to give. And the default, I think, is you think, I've got it in joint tenancy. I don't have to think about anything ever again. But the surviving joint tenant can do anything they want because they own the property 100%. Real estate, investment accounts, bank accounts, everything.
Yeah,
and you may not want that.
Yeah, well, when we bought that property together, you were planning on giving it to your children. Mm-hmm. And when you died, I remarried someone else and I gave it to her kids.
Right. So I saved a little bit of hassle, with not having to get a trust or not having to do a will. But my kids just got the short end of the stick, and all of my beneficiaries are completely out of luck because Pete's got it 100%. And think about it, if you have three, like maybe with siblings, like I own a piece of property with my two brothers, and it's in joint tenancy, and I'm the only lawyer, and I keep saying I just want to give it to you. I don't want to have a joint tenancy with anybody, because now you've got three people, who have to fight for it. So here's the alternative to joint tenancy: is tenants in common. So in that case, let's go back to Pete and me buying some investment properties. We buy one as tenants in common. That means that I own 50% and Pete owns 50%. So that when I die, it doesn't necessarily transfer to Pete. It transfers to whoever my beneficiaries are under my will or my trust. So it's useful because it gets two names on property, and sometimes you need it for financing, or you need it for the business of dealing with that property. But it's not going to help you much with estate planning because it doesn't make anything happen. Joint tenancy makes something happen. So we'll keep going. Community property. California is there's only 8 states in the country that have community property. really good tax benefits for using community property as a way to hold title. But between a husband and wife, it used to be you would take that property and it would say, Pete's selling to Jane and John Smith, comma, husband and wife, comma, as community property, comma, and that made it their community property, right? And that deed really helps because when you're down the road and you're looking at income tax bases and things like that after a death, having something in writing is great. But remember intestate succession. Intestate succession assumes you're going to leave your community property to your spouse, but legally you don't have to. You can leave it to somebody else. Really messy situation if you try to do that, but you legally can do it. The other issue with community property that's changed over the years is that it used to be an automatic thing, just like our joint tenancy or our individual named account with a POD. Right? As soon as one of the spouses died, it transferred over to the survivor. Then, at this point, maybe 10 years ago, California introduced this new thing, the very bottom thing, community property with rights of survivorship. And that means that we are identifying an asset between a husband and a wife as community property, and we are putting on top of that this automatic move when one of them dies. So the right of survivorship just means that the surviving spouse automatically gets the community property without anything else going on. He or she waits for a death certificate, records it with the county, and that's the end of it. It's kind of weird that you have to record with the county the death certificate that the other part of the county produced, but you have to. And it's just important to know that, in there's a death, even if it's community property or joint tenancy, there's still something to do to clear it all out. But so as you look at your assets and you think them through, think about how they're titled, because that's going to play a big role in what happens at death. And I'm going to just skip on over to that. So let's figure out your probate estate versus your taxable estate, because the taxable estate we're going to talk about just toward the end with some estate tax issues, but they're completely different things. Your probate estate is the list of assets that you own that a court or where you need to give instructions about where the asset is supposed to go. So if we go down through this list, right, in my individual name, nobody knows. I haven't been able to put on there where it's supposed to go next. Right now, I could do that pretty easily by using that pay on death, the second one. But a lot of people don't do that, or they bought a house so long ago, or they opened an account so long ago that pay on death wasn't really an option at the time. So individually named, individually held assets are very likely to end up in your probate estate. And that's just an estate, a group of assets where we need somebody else, like a court, to give instructions on what happens to the assets. Joint tenancy is not going to have that problem because we talked about it happens automatically, goes to the joint tenant. Tenants in common is going to be a problem because in that one, when Pete and I bought investment properties, I kept ownership to my 50%. I could tell who it's supposed to go to after my death. And if I don't do that, then we need somebody else to issue an order on who's that. We need a judge who's going to have to issue an order. Community property goes into your probate estate, but there's a fast and special, easier way for your spouse to deal with community property if it ends up in a probate estate. So what's all the big deal about a probate estate? Pete, do you want to have a probate estate?
Nope.
No, nobody wants a probate estate because that's the ultimate path to court. And we want to cut out all of these paths to court, right? So we don't want a probate estate. We want to do something that's going to give you instructions so that we don't have a court having to figure out what to do with it, right? So a probate estate are the assets that are going to head into a court. Now, what are you going to do? I don't have a slide on this, and I know this is going to be really important in the rest of the class. So I'm just going to introduce you to wills versus trusts. Right. So when you have a probate estate, By definition, it means you did nothing and you're intestate, or you did something, but what you did was you used a will, right? So think about my house again, that's in my individual name. I can't sign the deed to whoever's going to own my house after I'm dead, right? So we have to get a court order sent to the county, recorded in the chain of title, so that the person in charge of my estate, the person who's interacting with the court, my executor or personal representative sometimes, is going to need that. So I've got to appoint a person in a will who's going to deal with my probate estate and go to the court and put up with 9 months at a minimum, and probably more like 15 to 18 to 2 years of a process dealing with anything that's in my probate estate. So I mentioned that California likes to have creditors dealt with first. So California probate process says this: I die, Pete's my private fiduciary, he's going to become the executor of my estate. He's got to go to the court on all these assets that are in my probate estate and tell the court, Mark's dead, he's got these assets, he appointed me in his will to figure out what to do with all of this, and now I need the court to give me power to do it. And once I've done it all, I will come back to the court and explain it all, and the court will bless what's happened. And only then can the assets go on to my beneficiaries, right? And when a court gets a new probate filing, they will set a deadline for when they think you should be finished with it. And I know nobody can raise hands in this, so it's a little hard, but if you think that the probate proceeding is 6 months, just shake your head because you're wrong. 12 months, nope. The court will say in 15 months, we think you should be at a point where you can tell us how you're going to close this. It's not saying that in 15 months it needs to be done. In 15 months, you need to have a plan in place. So probate can last forever, it will feel like. It's expensive because on average, the probate costs that I've seen have been 4 to 5% of the estate. The biggest one being what you pay to the attorney, because Pete's going to hire an attorney, and the attorney's going to get paid for helping Pete, and he's going to get paid on a statutory scale. And so on $1 million of assets, the attorney's going to get paid about $22,000. Pete can also get paid $22,000 because that's the statutory scale. That's $1 million of assets. It's not hard in California to bump above that. And when you go above it, it's 1% on every other dollar. So it can add up really fast. I think the biggest probate fees I've ever seen were about $350,000 to the attorney and $350,000 to the executor.
And how much does it cost to do a will and trust in Orange County?
I know, if we talked about earlier, $2,500, $3,500, it's a heck of a lot cheaper.
Yeah. It's kind of reminds me of the Midas commercial. You can pay me now or you can pay me later. There's so many good reasons. And this is after your death, but incapacity is even worse. So we're talking about now the document, just a brief review: the Advanced Healthcare Directive, the durable power of attorney, the conservatorship appointment, the will, and you mentioned a living trust. Yes, so those are literally the essential estate planning documents that you need your attorney to draft. So let's spend a couple minutes on trust. I don't want to go into too much detail because I know you're going to get lots of this over 7 months, 7 weeks, a lot over 7 months. But here's the difference between a will and a trust. Okay, so a will is I sit down, I write it up, and I say on the day after I die, I want my assets to be distributed to these people and in these ways. And it's a set of instructions that applies only after I die. And the way to carry out that will is to put somebody in charge of it and know they're going to have to go through this probate proceeding that we've just been talking about. Here's the difference between a trust. A trust says, I'm going to take all those instructions about which beneficiaries I want,
and how I want them to be able to benefit from my assets. And I'm going to put them in the document. And instead of making this document effective only at my death, I'm going to do something to make it effective while I'm alive. I'm going to go ahead and I'm going to transfer my title to all of my assets, everything on this list probably, except maybe the ones with pay on death. And I'm going to put them in my trust. And I'm going to take title out of my name and put title in the name of the trustee, right? So who's that going to be? Well, in my revocable trust, I'm going to be the trustee as long as I can, right? But when I become incapacitated, I'm going to have somebody, Pete, whoever you pick, Trevor's on here, you've got lots of choices in who you pick, but you're kind of involving them now. And when you become incapacitated, they just step right up. You don't have to go to court. Your power of attorney for assets is useful, but at that point, your trustees are going to have full control of your assets, and they're going to be able to carry out your wishes.
So what I'm hearing you say is that for most individuals here in California, you're recommending a living trust.
I would, yeah. And I've tried to come up with what's the guide, what's the threshold? Is there a dollar threshold? And I really think the answer is dollars don't matter. This is a peace of mind question, and this is an efficiency question of, when I die and my heirs and my beneficiaries are standing around wondering what's happening, I want it to be as quickly and efficiently administered as possible, and that's a trust.
And for single people, so if you're single and you don't have a spouse or somebody living with you or cares for you, you gotta have a living trust.
Yeah.
Else you end up in a conservatorship.
Right. And the great thing about a living trust is, you start to get those phone calls, grandma, it's me, your granddaughter, when you don't even have a granddaughter, right? And there's, I'm traveling and I need some money. And, those are more and more sophisticated as the days go by. And, having somebody who's got experience administering these things, who's seen these scams, who can help, you push them away, help avoid them from getting into your life, it's a great value. And it's that having that trustee, somebody that you have talked to. It used to be that you would name a trustee and you just put a bank in there, and the bank would find out the day after you died, or hopefully the day after you died. Sometimes it was months after you died, that they had to do something, and you had no relationship. They weren't very helpful to you during your life. So I think the way things are happening now, where you pick somebody and you talk to them, and you meet with them.
Mark, we have about 5 minutes left, okay. And I don't know how many slides you have left, and but I want you to kind of maybe focus in on those areas that you think are absolutely sure. Important. But everybody remember, this is just an introduction. So we're going to go into detail on many of those things. And I see Don
making a point.
Yes.
There's a question, and it's an interesting one. We've mentioned pay on death, POD. What about naming a beneficiary?
Absolutely.
Yeah. So the same thing?
Certain accounts, like your retirement benefits, your life insurance policies, they don't really do pay on death. Instead, they let you designate a beneficiary.
A POD is a beneficiary designation.
Okay, just making sure we had their comment.
Yeah.
Okay.
And by the way, don't think of these things as good or bad. Think of them as tools depending on your circumstances to use when appropriate. And that's where legal counsel comes in. Don't go to your real estate agent to ask about title. It has so many consequences, so don't think of these things as good or bad. They're appropriate in certain circumstances, no matter what your situation is. We've got about 4 minutes left, Mark.
Okay, I'm going to give you the quickest overview of federal estate taxes that you've ever had. Maybe the only overview you've ever had. But I want you to think about this. We talked a lot, if we go back up a slide, about your probate estate. But we also, when you get into estate planning and when you get further into these series of classes, or workshops, the idea of a taxable estate is going to come up. And I just want to give you a heads up on what that is. The IRS says that anybody who's a US taxpayer can leave $12.06 million to anybody that they want, and they don't have to pay an estate tax. But every dollar over 12.06 is going to be taxed at 40%. It's a tough tax break. I mean, it's a big tax bill. This number, when I started practicing, the number that you could leave without worrying about estate tax was $600,000. And it has ratcheted up and ratcheted up. And now it's at a place where, a lot of people don't think about the estate tax anymore, because if you're single, $12 million is a lot. If you're married, twice that, $24 million is even more. But if you are thinking about your taxable estate, I want you to look back at this list and see they're all in black. We haven't been able to exclude anything from your taxable estate. The taxable estate from the IRS's point of view is any asset you own any interest in or have the right to use. So your taxable estate will be very different from your probate estate, usually be much bigger than your probate estate because it includes everything. And when you have this, here's our 40% at $12.06 million a person. Now, the issue that I bring this up, and I want you to start to think about taxable estates in your head, is that our $12 million, we know it's going to disappear. At the beginning of 2026, it's going to cut in half. I have to draw a little distinction here. This $12.06 million is $10 million plus a bunch of inflation adjustments, because many years ago, that's what we got. We got a $10 million exemption, and it gets inflation adjusted pretty much every year. But in 2026, it's going back to $5 million plus inflation adjustments, which will probably land at around $6 million. So if you're now thinking about a $5 million estate leading you to a federal estate tax problem, that's a whole different thing. That's still a lot of money, but it's really easy to do that. And so you got to start to think about, are you going to have an estate tax, and what kind of planning should you do, which will be discussed in a lot of the other sessions. But I wanted to at least put it out there.
By the way, and the federal estate tax is totally avoidable.
Mm-hmm.
Okay, this is why you're paying the big bucks to Mark. It is almost voluntary. Okay,
yeah, well,
if you give him time and allow the expertise to work, the federal estate tax is avoidable, but you need to get in front of an attorney to do so. So is there any other slides on here that you want to discuss quickly?
Just one more. Okay, so we've talked about the federal estate tax, right? So here is a list of states that have their own estate tax.
California's not included.
Or
I'll
an
wave the
inheritance
flag.
tax. Right, you're right. You see the big question down in the bottom. Where are you, California?
Yeah.
We don't have an estate tax. So it's one way that our tax system is favorable to us. But you can look, even if you look down this list, it's only like 17 states that still try to do their own estate tax. But if you have property in any of these estates, real property in any of these estates, you need to think through, are you going to have an estate tax or an inheritance tax issue?
If you have property in another state that is taxable, but you have it titled in a living trust, does that still subject that property to an estate tax in that particular state?
Yeah, and that's I wish I had an easy answer to that question, because some states
depends.
It's going to be depends, because some states say, well, where's the trustee? And if the trustee's in our state, we're going to tax. Some states say, if the real property is located in our state, it's subject to our estate tax.
So if you have a lot of money, there's a lot of moving parts, you need professional help.
Yep.
Okay, there's just no other way to go about it because of all of the rules.
Mm-hmm.
I mean, every state is a little bit different. There's tax issues, there's family issues. It's complicated. Mark,
and just
great job.
Oh, thanks. Let me it just made me think of one thing. We were talking about fees in the beginning. So you look at fixed fees and most people do estate planning on a fixed fee. But if you're trying to figure out, is an attorney going to be able to help me with these estate tax issues? You're going to be looking at spending $500 or $600 an hour in an hourly
Minimum.
rate. Yeah. So when you see somebody and they say, well, my hourly rate's $350, you can almost in your head know they're not going to be great for you if you're doing estate tax planning.
And by the way, it's also true the opposite. If you have a smaller estate, the last thing you want to do is go to a high-end attorney because they haven't had the experience with the smaller estates. And when we talk about smaller estates, we're talking 1 to 3 million. So,
Yeah, like every plan that I think about has got layers of complexity because that's the thing I'm used to.
Mark,
if you don't need
stop
it,
sharing.
Okay.
No, keep talking, but stop sharing your screen.
Oh, okay.
Because that was your last slide, so we're good.
Yeah. Stop share. Hold on. There it goes.
There you go. That's it. Perfect. Nope. That's all I want you to keep talking. That's good. That's
okay.
So anyway, last words, Mark. Encourage people to do an estate plan.
Yes, really. It's not super hard. It's the documents are out there. Every attorney who's going to do this has every bit of the document that they're going to need to put together for you in their computer. What you're paying for is for them to give you the right set of provisions. And that means you got to talk to enough people to feel like you're really getting what you want to do and you're really understanding what they're going to do for you. If you talk to an attorney and you leave the office and you have no idea what they just said, keep shopping because you need to be able to understand what plan they're giving you.
Yes,
but
absolutely.
Do shop. Go out there and find an attorney.
Yeah, use that ask first form and don't be embarrassed about asking about fees. There is no group of attorneys who get together and say, okay, what are we all going to charge? Everybody is different. Everybody has different setups, different paralegals, different office rent. It's all over the board. So ask questions. You cannot insult an attorney.
I don't know, Pete.
Any questions? Don?
No, we're doing good. I just need to answer this one right here. Anyway, actually, some people apparently like us, Pete. That's a doggone good thing. Anyway, I thank you very much, Mark. It is wonderful again to see you. You do a fantastic job in terms of covering this and extremely professional in terms of what you do. This has been It's Your Estate, week number 1. And incidentally, Mark, there are now only 5 additional weeks. It's now a 6-week session. We changed it. That's why we had you go first, because you explained it all to us. So I thank you very much, and we will see you next week. Have a good one. Bye.